I'm here with attorney Harry F. Bosen Jr. in Salem, Virginia, and he's going to answer some questions about reckless driving and other traffic violations for us. So first, in Virginia, what constitutes reckless driving?
Reckless driving is any kind of a traffic infraction that involves endangerment of life or property or both. There are many forms of reckless driving. There are reckless driving by speed, where if you are traveling in excess of 80 miles an hour in Virginia in any zone, that can be reckless driving. Also, reckless driving is 20 miles an hour over the limit in any zone.
And what are the possible punishments for a reckless driving conviction?
Reckless driving is punishable by up to 12 months in jail, a $2,500 fine, or any combination of those two. In addition, you can lose your license in Virginia, or your privilege to drive in Virginia, for up to 6 months. And that suspension, if you receive it in Virginia, could be sent to your home state if you live outside of Virginia, and you could receive a suspension in that state as well.
And what can an attorney do in a reckless driving case that someone who's not an attorney would have difficulty doing on their own?
Well, an attorney's going to know the particular judge and particular court and what needs to be done, not done, in order to get the charge either reduced, dismissed, or thrown out. First, an attorney knows how to defend the case if the evidence is insufficient as a matter of law. Secondly, an attorney who knows what he's doing in that particular court and under that particular judge will also know precisely what you need to do as a client before you come to court to present yourself in a manner which will be in mitigation of the charge so that the charge can be dismissed or otherwise gotten rid of, or at least reduced. And an attorney with the experience that I have of 42 years is going to know that in whatever court he practices in.
What should someone consider when looking for an attorney to help them with their reckless driving case?
You really need to look for an attorney that's got experience, an attorney that has a good reputation with the judges, an attorney who has a good reputation in the community, an attorney that knows how to try a case, who's got the experience to try a case, who is well liked among his peers, among the prosecutors, among the judges, and other staff in the court. Experience is a key factor, but likability and respect among the judges and prosecutors that attorney's going up against is critical. I, of course, have that in all the jurisdictions in which I practice. Not all attorneys that you might hire have that. Attorneys that would write you a letter and try to solicit your business probably don't have that kind of experience and do not have that kind of reputation with the judges and the prosecutors.
How do you typically approach defending reckless driving cases?
It depends on the facts of the case. If the facts, in my opinion, are insufficient as a matter of law, I'll defend the case by cross-examining the state's witness or witnesses and by placing my client on the stand if I deem it's warranted to testify, and I'll prepare the client to testify.
What factors affect the outcome of a reckless driving case?
Well, a lot of factors. The nature of the charge, if it's a reckless driving generally, whether there was an accident or not, the nature of the driving that the trooper says caused him to write a reckless driving generally ticket. All these factors play into it. The speed, if it's a reckless driving by speed, if it's a very high speed case, I handle the case one particular way. If it's not egregiously over the limit, then I'll handle it a completely different way.
And what are some of the consequences of a reckless driving conviction?
One of the main consequences, of course, is you can go to jail, you can receive a high fine. But other than that, there are other consequences that are not directly associated with the court, but are directly associated with the consequences after court. One of those is your insurance could go sky high. Your job could be threatened if you drive for a living, or if you're needed to drive on the job. Security clearances. I've represented lots of people who had very high security clearances, including one person who actually had the highest possible security clearance as he was stationed in the White House, charged with reckless driving by speed, and I was able to get that reduced to a simple speeding case, which saved his security clearance. The other thing is it's a Class 1 misdemeanor. Many employers won't hire you if you have a Class 1 misdemeanor, and many times a regular employer contracts with the government, which requires you to have a security clearance, and that may be affected if you have a Class 1 misdemeanor conviction.
If a defendant hires an attorney to represent them on a reckless driving case, how does it work with whether or not they're required to appear in court with their lawyer?
If it's a real high speed or an egregious reckless driving case or an accident case, your appearance is probably going to be required by that attorney, by an attorney who is experienced. Generally speaking, many times judges will allow an attorney to represent the client without the client being present. However, there are many times when the attorney may make the decision that it is incumbent upon the attorney to have the client present because of the nature of the case and because of the tactical decision to have the client present because of the effect it will have on the judge. The danger in that is if you appear, the judge can put you in jail on reckless driving whether you have an attorney or not. If you do not appear, the judge may issue a capias for your arrest, but generally speaking, if you do not live in Virginia, a judge would not issue a capias unless it's a really egregious speed or egregious reckless driving case, at which time they may issue a capias and not allow the case to be tried anyway. But in most cases, I can appear for the client on reckless driving without the client being present. Again, if there's an accident or the speed is pretty high and they live in Virginia, they're going to need to come to court.
For less serious driving-related charges, like simple speeding or other traffic infractions, what are the consequences of conviction, whether the person who's charged goes to court with or without a lawyer? And is there any disadvantage to just paying off the fine and costs prior to the court date?
If you pay it off, that's the same thing as a guilty plea. So if there's an accident on a case, for example, you're charged with following too close or maybe simple speeding that does not absolutely require your appearance, you pay it off. That is an admission of guilt that is used against you or could be used against you in any civil proceeding if you were negligent and the other party files suit against you. If you pay it off and there's no consequence of having that guilty plea on your record, it's still a consequence in that it gives you negative DMV points on your driving record. It affects your insurance negatively, and it can affect some jobs negatively. So you want to hire an attorney for any kind of a minor traffic case, speeding case, anything, in particular speeding over 20 miles an hour or reckless driving or anything over 80 in Virginia. You want to hire an attorney to represent you on those cases.
If someone's charged with reckless driving or has some other type of traffic ticket or charged for another crime, if they call your office, what can they expect as far as free initial consultation?
First of all, I'll consult with them either over the phone or in person, free of charge. I do not charge for consultation. if you hire me, you pay my fee, then I am your attorney, and I will consult with you in person or over the phone as much as you need, or the attorney needs me as your attorney.
Mr. Bosen, thanks for talking with us about reckless driving and speeding, these charges, and what someone should look for when hiring a lawyer to defend them on cases like this.